This is the FOIA litigation update. Don't worry, you're in the right place. Although my slide says recent records access cases, you'll see as we get into the material, we've chosen to call it records access cases because although the District of Columbia, like the federal government, refers to these types of laws as FOIA laws, you'll notice that not all jurisdictions or states use the term FOIA. Some of them have different terms to describe what is essentially the same type of law. So we're going to go ahead and get started first talking about procedure. So in the District of Columbia, there are 2 tracks for appealing FOIA decision. The first is the Administrative Appeals track through the Mayor's Office of Legal Counsel, and those rules are set forth in 1 DCMR section 412. And this is by far the most popular track amongst requesters filing an appeal, and that's for a couple of reasons. One, it's cheaper. You don't have to pay anything to do it, and it's more straightforward. Additionally, it's a little bit quicker because within 5 days of receipt of a request for an appeal, the agency has 5 days to respond. And then within 10 days of the filing of the appeal, the MOLC will issue a written determination of its decision. Now, just because, sorry, just give me one moment.
Your slide. Stop sharing and go back. Okay.
Here's, I have an issue with my slide, so if you'll bear with me one moment, I'm going to try and get that rectified.
Yeah.
I'm trying to share again. If someone could let me know, are you able to see?
Still see your slide shorter view.
Got you. Okay.
I believe middle of the menu under slideshow. That looks like that may have done it. If you can go ahead and advance the slide. Yes, you're now moving forward.
All right, so you all can see me now?
Yes.
Okay. Sorry about that. Okay. So let me go over that again. Since the slide was not keeping up with me. So as I was mentioning, there are two tracks. The first is the MOLC, as I was describing above, and then you'll see there you can find procedural rules at 1 DCMR section 412, or alternatively, requesters can appeal through the Superior Court of the District of Columbia. Now, one of the reasons why requesters don't do this quite as often is there's a little bit more involved to it than filing an appeal with the MOLC. For instance, the Superior Court has filing fees. You are also subject to the Superior Court's calendar, which can be, and at times, much lengthier process than a MOLC appeal. However, one of the kind of pros of going through the Superior Court is they do have mediation, so that would also be something that you would be able to get in DC Superior Court that would be a little different from the MOLC. And you'll see at the bottom here, I have put the DC Court's website with all of the explanation for how you go about filing a civil action in DC Superior Court. And next, we're going to talk a little bit about finding the law in the District of Columbia. And again, please let me know if at any point the slides aren't advancing. So there's a couple of ways in which to do this. You can search in Lexis. However, just be aware that any searches in Lexis with regards to these types of opinions are only going to go back to about 1998. So, for example, here, searching for opinions on exemptions, you could enter in Freedom of Information Act appeal or FOIA appeal, and exempt with the star, and then 2534 in quotation marks, which is the number in DC official code, or 204. Similarly, you could do the same kind of search in Westlaw, although some of the terms and connectors are a little bit different there. For free public sources, there are the dcregs.dc.gov, which contains decisions from 2009 to the present, and the DC Register Archives, which has collections from 2003 through 2009. Also, if you are so inclined to do an old school search, you could go down to the library, to the MLK library, and check out the library's Washingtoniana collection, which is on the 4th floor, or a similar collection. And you could consult the indexes at the start of each year of the register, and you would be looking for Freedom of Information Act appeals, FOIA, or District of Columbia Freedom of Information Act, etc. Okay, next, you'll see something that one of our former colleagues came up with. This is a search term that you could use to, in searching for FOIA cases that would bring up a wider variety of cases on this subject matter. So you'll see, kind of as we were discussing earlier, it uses different variations of the term Freedom of Information Act, as well as public records and record access, to kind of cast a wider net, especially in instances where there might be a case that doesn't necessarily say FOIA, but would be discussing record access, or access to government data, etc. Now we're going to get into some specific appellate opinions. Also, I meant to mention at the beginning, if at any point you have questions, you can put them in the chat. My colleagues are monitoring that, and they'll try and answer. Otherwise, feel free to ask me at the end. Legal boilerplate, okay, but not question marks. Okay, so in this instance, we're going to compare two cases here. Chicago Justice Project versus the District with Henry Rose. A little ahead of myself here. Okay. So in the Chicago Justice Project, we had kind of a long legalistic request for documents. I'm going to pull up this slide. And you'll see, I know it's a little bit difficult to read. It's kind of small. But the point being that they've given a really detailed request here. This was a request to MPD for records, and you'll see they asked specifically for copies of the below listed records, and then they give definitions of what they're looking for. Records or documents, database, a data dictionary. They define pretty much everything that they're looking for. And then they also included instructions related to the documents that they're looking for. Okay. Their second request said, please provide records sufficient to show each public or private entity, whether on the federal, state, or local level, that can view or otherwise has access to the data within each database detailed in request A1. C2, it says, please provide records sufficient to, I'm sorry, I'm just reading that again. It's a larger version of the picture that's there. So initially, MPD had rejected this request on the basis that the Chicago Justice Project was essentially asking them to do kind of the legal research for them. However, the court found that this was a valid and well-phrased request and then remanded the case. Second page of that. Sorry, here's the slide that I was reading from. Okay, by contrast, in Henry Rose, a request was sent also to the Metropolitan Police Department. And the request was related to the head of the unit of Rio de Janeiro, Brazil police investigating communist activity in that country. Is said to have contact with police in Washington, D.C. sometime between 1933 and 1939. The person in question was Captain, and then his name has been redacted, but the request did include the name of the individual. And so the requester asked, do you have any records of communication with this Brazilian officer? Okay, and MPD initially responded by sending a letter acknowledging the request and informing the requester of its fee schedule. The requester then responded, while I am willing to pay, I do not need more than a simple yes or no plus the date if the Brazilian police captain in question was asked to have some kind of contact with the police in Washington, D.C. in 1936 or 37, and by whom he was asked. The requester said that would be nice as well if it's available. And he said, I do not need copies of any documents. So based on these additional statements, MPD denied the request on the grounds that FOIA does not require agencies to perform research, analyze data, answer written questions, or create records in order to respond to a request. And in this case, primarily because the initial request, we'll go back, look, do you have any records of communications with this Brazilian officer? It contained a question mark, kind of an open-ended question there. And the court said, we agree with MPD that it is not obligated to create records for you. And sorry, I'm saying the court, but in this case, it was a MOLC analysis. Moreover, DC FOIA does not require MPD to perform legal research for you. Next, we're going to talk a moment about leading MOLC opinions that mention GLOMAR. So some of you may be familiar with GLOMAR in the federal space. So GLOMAR is a case that came out of a Soviet nuclear submarine that sank in March of 1968. It sank in the Pacific Ocean off the coast of Hawaii. After searching for it for a number of months, the Soviets gave up. However, the US government, particularly the intelligence services, decided that it would be a good idea for them to find and retrieve this submarine. So they devised a secret plan to recover it using a ship that belonged to billionaire Howard Hughes, which had a metal claw attached to it that was going to go out and find and try and pick up the remains of this nuclear submarine. So somewhere along the way, in the early 70s, a journalist caught wind of this essentially top secret project and started asking questions. They attempted to FOIA information on the project. However, the intelligence services responded by saying that they could neither confirm nor deny that they had responsive records or that such records existed. And at the time, the logic behind that was that, either confirming or denying the existence of this ship and of this project would be a threat to national security. Anything that they said would be revealing as to what was taking place. And so in DC FOIA, there is not necessarily a specific mention of GLOMAR, but the principle is established through MOC opinions, such as the two that you see down here, Hannigan and Zangari. But it is a similar rationale where, for instance, like in the case of employee disciplinary records or something, if those were FOIA'd, and the agency might want to respond that it can neither confirm nor deny the existence of those records, because obviously in such a situation, even acknowledging their existence would allow someone to know that the individual was subject to a disciplinary action. Next, we're going to talk about public interest versus privacy interest. And these are several MOC opinions. 2019-238 Zavala, which the MOC affirmed the exercise of Exemption 2 because adequate public interest was not demonstrated with respect to third-party Uber receipts. Okay, similarly, in Espino, the MOC affirmed the exercise of Exemption 2 because adequate public interest was not demonstrated with respect to a victim impact statement. Then by contrast, in Pearson, the MOC found that there is a public interest associated with the resume and application of a successful candidate for a government position that outweighs any applicable privacy interest. And with situations such as that, you might find that the more high profile or prominent the position, the higher the degree of public interest in what might otherwise be a document that has a privacy interest with it. Okay. There's another MOC case related to a requester of records, including personally identifiable information, where the requester was himself the subject of the request. Okay, so this involved a case with an individual named Winters who had requested information from MPD that included personally identifiable information, like a social security number. MPD initially saw the request and denied on the basis of Exemption 2 with regards to personal privacy. However, the MOC ruled that the requester was the subject of the record sought, and therefore the privacy interest that would typically protect those that information or those records was negated. So the MOC remanded the case and instructed MPD to proceed with processing the request after verifying the requester's identity. There's some more court cases out of DC. First is DC versus Terrace Pravlik and Million LLP. And so in this case, Terrace Pravlik and Million is a public interest law firm, and they were seeking budget documents from the mayor under DC FOIA. And they sought documents that were related to budget requests for the DC public schools and the Office of the State Superintendent of Education for fiscal year 2019. So initially, the mayor refused to produce draft submissions and claimed that they were protected by executive privilege. TPM then filed a complaint in DC Superior Court for the documents and their online publication. So the Superior Court denied the mayor's motion to dismiss and granted TPM's motion for summary judgment. The court ordered the mayor to produce the requested documents and to comply with the publication requirements of DC Code 2-536. The mayor appealed that decision, arguing that the documents were protected by executive privilege and that the law firm TPM lacked standing to enforce the publication provision. So the case then went to the DC Court of Appeals, and the court rejected the claim of executive privilege, in part because it said that the budget process involved overlapping responsibilities between the mayor and the council, and so thus it couldn't be under the exclusive control of the executive branch. So the court also found that TPM had standing for the enforcement of the publication provision. It found that the failure to disclose the documents caused concrete and particularized injury to TPM, and then it affirmed the Superior Court's order requiring the production and online publication of the requested budget documents for fiscal year 2019 to the present. Okay. And then another case, this one is currently ongoing, Gooch v. District of Columbia. Here, the requester sued the district for records related to his conviction. He then received partially redacted records. And for a period, the two parties agreed to work on redactions. However, they reached an impasse, and the requester plaintiff alleged that the remaining redactions are insufficient as a matter of law. And so now the two sides are again back in court to determine whether or not these redactions are appropriate, or if MPD will have to release further unredacted material. And now we're going to look at some cases from other jurisdictions. Okay. First one is Gonzalez v. Miller, which is from my home state of Georgia. In this case, the Georgia Supreme Court held that the state's Open Records Act applies to records maintained by district attorney's office. So a little background on this case, the requester sought records from a district attorney that were relating to various functions of the DA's office, including ones showing staff shortages, large caseloads, violations of crime victims' rights, and failure to effectively prosecute criminal cases. The district attorney declined to disclose the records and argued that neither she nor her office was subject to the Open Records Act because she is a judicial officer and pursuant to Georgia's Constitution, and that this particular law only applies to executive branch agencies. The Georgia Supreme Court rejected this argument and reasoned that the state constitution vests judicial power exclusively in the courts. They found that district attorneys exercise executive power because of their function to enforce the law by prosecuting criminal cases, and that they have no judicial power because they do not decide cases. Next, Teague v. Chavez. This is a case from the Supreme Court of Iowa that held that the Iowa Open Records Act protects confidentiality of job applications received from external candidates, but does not exempt disclosure of applications submitted by current government employees. So here, the requester was seeking several records that were related to the hiring process for the city clerk and city attorney positions for the city of Cedar Rapids, Iowa. The city refused to disclose job applications, claiming that they were confidential under Iowa's Open Records Act. The Iowa Supreme Court held that job applications from external applicants were exempt from disclosure under the law as communications made to a government body or to any of its employees by identified persons outside of government, where the government body receiving communication could reasonably believe that those persons would be discouraged from making them to that government body if they were available for general public information. However, with respect to applications by existing government employees, the court held that job applications did not constitute personal information or confidential personal records that is protected from disclosure under Iowa's Open Records Act. And thus the city was obligated to disclose the applications that were submitted by current employees of the city, although it was still able to withhold the external applications. Next up is City of Portland v. Kessler. This is a case out of Oregon. The Oregon Court of Appeals held that employees' personal cell phone numbers were subject to public disclosure, affirming a county district attorney order and a circuit court decision ordering the disclosure. So the background in this case, the request was made to the city of Portland regarding city-issued cell phones. Specifically, the requester sought metadata of all numbers that exchanged text messages with city-issued cell phones, including dates, senders, and recipients, and if possible, their names and other identities, for every message that was stored in or exportable from the city's archival service. The city claimed that a staff member would have to review the metadata to find and redact employee personal phone numbers, arguing that the state's public records law exempts them from disclosure. The court in this case concluded that the categories of information listed in the exemption provision, for example, public employee residential addresses and telephone numbers, personal email addresses, driver's license numbers, employer issued ID card numbers, emergency contact information, social security numbers, birth dates, are exempt only when they are contained in personnel records. And the court determined that the city issued cell phone metadata were not personal records, and that therefore any personal employee cell phone number that was contained therein could not be redacted from the disclosed records. And the next case is Eddington v. DOD. In this case, the appellant emailed the Department of Defense 14 different kind of components at the Department of Defense to request records. He did not receive a response after, and I believe after about 7 months or so, he filed a complaint in the district court seeking to order the Department of Defense to conduct a search for and promptly produce the requested records. The Department of Defense responded by moving for summary judgment, because they essentially searched their system and said that they had no record of his request. The district court granted the department's motion, and then the DC Circuit Court affirmed the district court's ruling, and it said that it afforded a presumption of good faith to the department, that it had conducted a search that is relatively detailed and non-conclusory and submitted in good faith. And they determined that the requester had presented insufficient evidence to create a genuine dispute regarding the department's receipt of his FOIA requests. And just a few more cases from some other jurisdictions. I'm probably not going to pronounce this correctly, but I think Herstedt v. the City of Sault Ste. Marie. This is in Michigan. On remand from the Michigan Supreme Court, the Court of Appeals held that a police department could not withhold portions of its use of force policy from public disclosure by invoking the state's Freedom of Information Act exemption for law enforcement staff manuals. Then Michalski v. Department of Corrections. This is a case out of Pennsylvania. The Commonwealth Court of Pennsylvania held that data available on Netflix's website identifying histories of movies that the Department of Corrections ordered were public records within the meaning of the state's right to know law. I thought this one was kind of interesting, just with respect to the Netflix connection. So the background of this one, an incarcerated requester requested records from the Pennsylvania Department of Corrections, specifically a list of movies ordered from Netflix for 8 correctional institutions between June of 2019 and October of 2021. The requester wanted the information printed from Netflix's history tab. The Department of Corrections denied the request, basically saying that these Netflix histories were not in the Department of Corrections' possession, custody, or control. So the requester appealed to the Pennsylvania Office of Open Records. The Department of Corrections contended that it does not maintain these Netflix records directly, And initially, the Pennsylvania Office of Open Records upheld the Department of Corrections denial, and it reasoned that Netflix histories are external to Department of Corrections records, and that even if the department had accessed them, they're not public records as defined by Pennsylvania's right to know law. So once it reached the Commonwealth Court, the court reversed the decision of the Office of Open Records and explained that the first step in evaluating a request requires the agency to discern whether the requested records are within its possession, custody, or control such that it may be obligated to disclose them. Court went on to say that Pennsylvania's right to know law defines records in pertinent part as information, regardless of physical form or characteristics, that documents a transaction or activity of an agency and that is created, received, or retained pursuant to law or in connection with a transaction, business, or activity of the agency. And so the court went on to explain that it's evident that data available on Netflix's website identifying movies that the Department of Corrections ordered from Netflix for use in its facilities documents a transaction or activity of the Department of Corrections and is created, received, or retained in connection with a transaction, business, or activity of the department. So the fact that they are in Netflix's possession and are difficult to print off directly from the website does not change the conclusion that they are public records that the Department of Corrections must disclose. And then our final case from another jurisdiction, Town of Greenwich, the Freedom of Information Commission. This is from Connecticut. The Connecticut Appellate Court held that public agencies must search for and review records requested pursuant to the Connecticut Freedom of Information Act to prove that they are exempt from disclosure. And so in this case, the requester sought police department records showing all changes made to an investigation file and arrest warrant application. The requester offered to provide the police department with detailed database commands to help retrieve the records and to pay any cost if a technician was needed. Without conducting a search for responsive records, the police department contended that the requested records constituted preliminary drafts, which were exempt from disclosure under the Freedom of Information Act. The Connecticut Freedom of Information Commission concluded that the police department failed to prove the requested records were exempt from disclosure and that the agency must review the requested records before it could conclude that they were, quote, preliminary drafts within the meaning of the Freedom of Information Act. The Connecticut Superior Court had sustained the police department's appeal, determining that the requested records were preliminary drafts under the act and that review of the records was not necessary. However, the appellate court disagreed and held that the commission had correctly concluded that the police department did not meet its burden of proving that the records were exempt from disclosure since it failed to search for and examine the responsive records. And then this next slide is just a few kind of key cases here coming back to the district with regard to adequacy of search. First is Doe v. MPD, which contains a test for evaluating the adequacy of a search for responsive documents. FOP, Fraternal Order of Police v. District, also known as the Peaceaholics case. This case deals with deliberative process privilege, as well as adequacy of search in the district. Another case dealing with the Fraternal Order of Police, FOP v. District. This is the so-called no void for volume case, which essentially establishes the rule that void for volume, meaning that just because a request is voluminous, that in and of itself does not void the request. So I know this is a pet peeve for many in the FOIA space here in DC. So even if the request is very voluminous, that in and of itself does not void the request. You still have to search for relevant documents. And then lastly, Leith v. MPD, which is a dictum case from the MOLC. And then lastly, a slide that we've included for the last couple of years that was also developed by a former colleague regarding the case law standard for responsive adequacy. So one, show that the search was reasonably calculated to uncover all relevant documents and follow any leads along the way that likely will yield, not just might, but likely, more responsive records. And then B, evaluate your search in hindsight as you go along, and don't just stick to the initial provisional plan you might have had at the beginning. And then 2, be prepared to adequately explain, such as in an affidavit, both how the search was conducted and why it was conducted in that manner. And just a little tip at the bottom, it'll be easier to support that with a contemporaneous record kept in a routine, consistent, organized way. Sorry, I feel like I was talking a mile a minute. So certainly, if there are any questions, now would be a great time to ask them. Also up here, you can see contact information for us over here at the Office of Open Government. So if you need any assistance with FOIA, which is the subject of our talk today, or also with the Open Meetings Act, which our office enforces, you can either give us a call or send your questions to our email at opengovoffice@dc.gov. And then our office is comprised of our director, Nikel Allen, Chief Counsel Louis Neal, my colleagues, Anthony Skirbo, Attorney Advisor, Joan Lelma, Attorney Advisor, our paralegal specialist, Kim Brown, as well as our IT specialist, Kevin Brown. And again, my name is Brandon Lewis, an Attorney Advisor here at the Office of Open Government. And I'll go ahead and open up for questions if there are any. I can't quite see the chat, so if colleagues could let me know if there's
nothing in the chat.
Hi, I have a question. This is Tanya Condell with DHCD. How are you?
Good. How are you?
I'm good. So for the voluminous requests, you said that we can't automatically cancel the requests, but we can ask for clarification, right?
Yes, you can ask for clarification.
So they can narrow their search.
Yes, ma'am.
Okay, and if it's still voluminous, so they narrow it down as narrow as they can. We can still send out on a rolling basis because some of these, especially for DHCD, what they're asking for, the documents are voluminous and it takes a lot of manpower. I know the federal government has a statute stating if it's voluminous, then no bueno, but we don't. And do you know of what is happening with the reformation of the FOIA statute? Because we're hoping that would be included as well. Sorry, that was kind of a combo.
Oh, no problem at all. Definitely to the earlier part of what you were stating, in cases where there's a particularly voluminous request, we do generally recommend that you try and set up a production schedule with the requester, kind of exactly as you had mentioned, whereby you'll agree upon intervals in which you would produce the documents in order to kind of make it easier on you as the FOIA officer to provide what's being requested. But you are correct. There's no void for volume in DC, so you can't just outright deny the request just because it's voluminous and going to take a number of kind of productions to get it all the way out there. With regards to your question about any reforms to FOIA, I am unaware of any that are going to be addressing that are on the table right now. But my colleagues are also on on the line. So if any of them are aware of any movement in that area, then feel free to comment as well.
I'm not aware of anything pending before the council or any, frankly, back channel discussion of making changes to the FOIA statute that would sort of alleviate the FOIA officers' caseload or processing time, I'm afraid.
Okay, I guess that was a rumor then, but thank you.
And then I know in the chat we had a question about what else was forthcoming in our FOIA webinar series. My colleagues have been kind enough to put descriptions in the chat, but just in case you're not looking at that right now, coming up next on July 30th will be categories of FOIA requesters, fees, and acknowledgement and denial letters. August 6th will be our FOIA advisory opinion review, in which we will present the advisory opinions that the office has issued so far this year with regards to FOIA. And then on August 13th, we'll have preparing for a FOIA civil case defensive litigation, and that will be facilitated by our colleagues at the Office of the Attorney General Civil Litigation Division. That one is usually a great one that's well attended. And so, if you can join us for any or all of our remaining sessions, we would love to have you. I see a question also with regards to the slides being available. As my colleague has indicated, they will be available on our website under trainings shortly after today's presentation. I'll stick around for a few more minutes in case there's any unanswered questions percolating out there. But if not, I will give you the rest of your afternoon back. Thank you so much for joining us, and we look forward to seeing you next time. I do see a question in the chat. I'm just wondering, perhaps the director might take this one. The question is, to the question of what revision to FOIA may be expected, will your office be willing to support an amendment suggested by an agency?
Hi, good afternoon. I'm Director Allen, and yes, we do advocate for the fair implementation of FOIA. And yes, we would be open to suggestions that we can pass on. If you have them, please send them to us. We send them to our mailbox, opengov@dc.gov, or to any one of us who are listed here on the contact information. And there is definitely a great need to revise DC FOIA. So we are in agreement with you on that. And if we can move the needle, we're happy to make the attempt.
Thank you, Director.
Hi, Mr. Lewis. This is David St. John with CAH. I had a question regarding the Court of Appeals decision in Terry. Do we anticipate any changes in any standard operating procedures with how agencies should interact with the Executive Office of the Mayor and Council regarding budgetary documents? Like as far as if there should be affirmatively placed on the website or something, or if we should read the decision as being, more narrowly tailored just to the issue within the Executive Office of the Mayor.
Brandon, I'll take this one. So yes, the TPM case that deals with the budget formulation, for those of you all who may not be aware, every year when the District of Columbia agencies formulate the budget for the next year, there are documentations that each agency, including independent agencies, submit to the city administrator. We have not received any guidance thus far from the Office of the City Administrator regarding what should be done for those documents as they're produced and retained from the policy perspective. So we don't have any advice to give about that. I would contact the Office of the City Administrator. Barry Kreisworth is their general counsel, or Betsy Cavendish, to get more guidance on that specific issue about the budget formulation documents.
Understood. Thank you, Ms. Allen.
You're welcome.
Yes, thank you, Director. Okay, not hearing any more questions at this time. I'll probably stick around another 3 or 4 minutes in case some of you are still thinking about something that you heard today. If not, again, thank you for joining us and have a great rest of your afternoon.